So now we have moved to chapter second, that is regulation of access to biological diversity. By this they mean like there will be some sort of conditions. Conditions will be in order to regulate access to the biological diversity. Once there will be regulation on this access, the biological diversity will not be exploited unevenly. So for that reason, Section 3 specifically puts some sort of regulations. It has specifically mentioned that only upon the approval by NBA, that's the National Biodiversity Authority, certain persons can undertake this biodiversity related activities. So randomly these people cannot undertake any sort of biodiversity related activities. For that, to carry out those these biodiversity related activities, they have to definitely get approval from the NBA. And who are those certain persons which are being regulated through this section? These certain people, they are being mentioned in the subsection second. That subsection second specifically named those persons. It has mentioned that the persons who are not citizens, they specifically have to be taken permission from NBA. Second, a person who is citizen, okay, well, but he is not a resident. That is, he is an NRI. He is definitely a citizen, but he is presently not residing in India. That's he is NRI. Okay, non-resident in India. And third, they have also mentioned that any body corporate or any association, or for that any organization, if that organization is not registered or incorporated in India, first condition. Second condition is if it is incorporated or registered, okay, then what is the problem if it is incorporated, if it is for say if it is registered? But if we find that in its share capital or in its management there are only non-Indian participants, so for that reason it has to take approval from NBA. Okay, so these via certain persons or for say organization who definitely have to take prior approval from NBA. Now in subsection first, they have specifically mentioned that no such person, it's only the heading of the section 3, that no such person which is mentioned in the subsection second, they will not be allowed to undertake any sort of biodiversity related activities but without approval of NBA. Okay, what sort of this biodiversity related activities? For example, if they will be obtaining any biological resource which are in the India, or they will be taking out, or they will be utilizing any sort of knowledge which is of Indian origin. So for that reason, they definitely have to take approval from NBA. Now in this section 4, it's talking about that if, for example, there is some research in India and the results of the research, it cannot be transferred to certain persons. they have also mentioned certain persons here. Who are those certain persons? The same we have found in the subsection second of section 3, that is above one. Who are those? Those were if any body, any person who is not a citizen of India. Second is if any person who is citizen of India but is not a resident. And third is for the organizations, that if any organization that's not incorporated in India, or if it is incorporated in India but at the same time the kept these shareholders or in the management, if there are only non-Indian. So for that reason, it has definitely to take approval from NBA. Similarly, they are talking about that if, for example, there is some research in India, and definitely there will be some results, and those results of the research, they cannot be transferred to certain persons without approval of NBA. So once you want to share that research results of the research, you definitely have to take permission. So why this permission? This way we are regulating the access. That is what we have mentioned. Now this has all exclusively mentioned that the transfer here, that it cannot be transferred. The word transfer, it does not include. For example, if you have done any sort of research and you are putting it in the publication or in the form of research paper, or for example, you are disseminating that sort of knowledge through some sort of seminars or any workshop. So, dear, this does not hold good. That is like, for that you do not need to have prior permission from NBA. You can do that. Okay. Now we have section 5. And this section 5, it talks about collaborative research projects. Like, for example, if there are some sort of collaborative research projects, it can be between the institutions. So between the government sponsored institutions, etc. So if there will be such sort of projects, for that section 3 and section 4, they do not apply. Okay, that is, if you have some collaborative research projects, you do not need to take approval from NBA. Then, but they have put a condition. They have put some conditions here. One of the condition is like, for those collaborative research projects, they have to conform with the policy guidelines which were issued by the central government. That it should be in consonance of the policy guidelines. It should not breach the guidelines which are issued by the central government. And second thing is, these collaborative research projects have to be approved by the central government. Once these things are there, then they do not need to take permission under section 3 and section 4. Second subsection of this section is that, for example, before the commencement of this act, there was some sort of collaborative research project. That collaborative research project, project, it will, if it will prevail. But if the provisions of the agreement, they are inconsistent with the provisions of this act. Firstly, there will be, for example, the provisions of this agreement of what? Collaborative research project. If provisions of that agreement are inconsistent with the provisions of this act, then it will be called as void. Simple. Now we are here. Here is section 6. This talks about that no person can actually apply for IPR. That is, no person can apply for intellectual property rights in or outside India without the prior approval from NBA. That is, for even for the application for IPR, you have to get an approval from NBA. This section also mentions that, for example, if a person applies for patent, intellectual property right, he has to make sure that after the acceptance of the patent, but before the sealing of the patent by patent authority concerned. So after the acceptance of the patent, but make sure that it is before the sealing of the patent, of the same patent by the patent authority. You have to get the permission of NBA. That's a must. This condition is must. Similarly, they have mentioned that this NBA that has to dispose any sort of application for permission within a period of 90 days. It cannot go beyond that. For example, if it has got any sort of application for permission, so from the date of receipt of the same, it has to be disposed within a period of 90 days. It has to be dispersed. Similarly, sometimes what NBA, while granting the same sort of approval for any sort of permission, it may impose any sort of fee, or it may ask for royalty or both. And sometimes it may put some conditions, like it may talk about the sharing of financial benefits which will be arising of, which will be dispatched out of the commercial utilization of such rights. It will be asking for benefit sharing. So that has to make sure. So it may ask for benefit sharing fee or royalty or for both. So that has to be make sure. Okay. If any person is making an application for any sort of right, for example, if he is asking for the IPR or any sort of right under some other law by the parliament, then the provisions of this section, it will not apply on the same person. Similarly, in the subsection 4, for example, if these rights are granted under some other law, then that party which will grant these rights, that shall endorse a copy of such document, whereby it will mention that yes, we have granted the right to national biodiversity, biodiversity resources to this person, and that authority has to make sure that it will provide a copy of such document to the NBA. Now we have moved to the section 7, and section 7 is all about that if, for example, any person wants to obtain biological resources for certain purpose, this is not any person, it is subjected to some exceptions. We'll be talking in the subsection second. So for example, if any person that is intended to obtain any sort of biological resources for certain purposes, for that it has to provide prior information, prior intimation to the State Biodiversity Board. So here they have mentioned that no person or nobody or no corporate, no association, no organization, it cannot obtain those biological resources for any sort of commercial utilization, for bioutilization and extra without the permission of state. It's not permission, sorry, It's here without intimation, without informing the State Biodiversity Board for the say. So once it will provide that intimation, after that it can obtain the biological resources. But it is subjected to some exceptions, like this section will not apply to local people or local communities, including there may be some growers, some cultivators, Vedas may be there, some Hakims may be there, who used to like this obtain those biological resources for practicing indigenous medicine. So they do not need to take this. They do not need to inform State Biodiversity Board for the same.